Thank you very much, Dean. Good afternoon, everyone. I would like to begin by acknowledging the work of the Native Law Center and the director, Saki Henderson, and Dr. Marie Batiste of the College of Education, and their early influence on me as a young legal academic. Their Summer Institute on Cultural Restoration of Historically Oppressed Indigenous Peoples in 1996 had a profound impact, as did their joint publication of their book on protecting Indigenous knowledge and heritage. I look at the opportunity that's been afforded by the Law Foundation of Saskatchewan's H. Robert Arscott Chair to be one of offering me the privilege to return to a place, an institution, where I encountered visionary and globally recognized Indigenous academics who worked tirelessly from their heart with an Indigenous mindset. And to Saskatchewan itself, the land and the people to whom this place was originally instructed, and to those not from here, but drawn to or called and privileged to be here, as I am. I also want to thank the students in my law and culture class here at the College of Law who have contributed to this lecture by providing me with questions on the subject of Indigenous identity. Hercom. I am a sitting appellate justice on my Pueblo's bench. I sit with three other justices, Chief Justice William Johnson, a lawyer and a longtime member of the tribal bar, and with our elder Justice Tony Lucero and Justice Roshana Toya, who is our newest member. As a member of the Isara Tribal Judiciary, I am mindful of my position, and I speak as a legal academic here. This is a picture of our tribal court complex. Our tribal court is located in this part of the building. This houses our tribal council. The tribal court in my community has a long history. It has acted as a court for about 40 years or so, and it has functioned for the people as a court in this location for about 3 or 4 years. This is a new location of the tribal court. In the area of Indigenous law, which I have been drawn to during my academic and legal career, I explore the theoretical in Indigenous law because that is where I feel that the area needs to be developed. But because theory is thought, for me it's not far from feeling and from experience. And it requires an acknowledgement of the way that it is in Indigenous communities and with Indigenous families, which is not the ideal, nor is it the romantic, but neither is it the stereotype. We are the people, and in this presentation, I address making law work for who we are. And I pattern my theory in this lecture. I begin with the historical context of law and courts in Native communities in the United States, and then briefly consider the modern text of tribal law, of both the historical and the present, and its message to Indigenous communities like the ones that I come from. To recognize really a very simple truth, that there are two legal traditions in operation in our communities, and that some work must be undertaken because they do not naturally fit with one another. The question that challenges us is how we restore a balance and an equilibrium between how we think and feel and how our law should work and function. Finally, I use law affecting Indigenous identity and mixture or enrollment as an example. My lecture today stems from a larger research project. I am considering law and Indigenous identity in the 21st century. Indigenous identity is the macro frame which I use to center a number of related subjects of significance to the existence of Indigenous peoples as unique peoples in social contract with one another. At the edge of the modern state, as Maven Lam's work describes it, from within their own frame of thinking. Here I consider Indigenous identity in relation to how Indigenous peoples construct group identity, or how lines of tribe are drawn both for them and by them. I look also at the concepts of Indigenous peoples themselves that they bring from their own knowledge base or worldview to this group identity, in contrast to external understandings and legal frames which disrupt and corrupt an approach to group identity as the people within the Chthonic legal tradition, one of the 7 major legal traditions in the world. The Indigenous understanding arising from the Chthonic legal tradition is instead embedded in Indigenous laws of relationship, which give rise to what I refer to here as a law of belonging and the concept of continuance. In an essay related to this work, I draw the phrase lines of tribe from President Barack Obama's 2009 inauguration speech, in which he referenced the need to unite and to transcend differences, and indeed to dissolve the lines of tribe that divide. The dissolution of the line of tribes, however, represents the end of group identities that give rise to individual tribal identity, which is not a goal of Indigenous peoples, but which was an articulated federal policy of the United States government for tribal peoples known as assimilation. As time progressed in the interaction between Indigenous peoples and discovering nation states, initially the colonizing nations and then the nascent settler states, which evolved into strong nation states in their own right, the demand and in some instances the need to assert who belonged and who did not belong to a tribe grew. Mixture with Indigenous peoples gave rise to questions of race, color, and status externally, of who belonged, which in turn became issues internally. Colonial and federal laws initially, and then as exported to tribes, turned on degree of Indian blood. Across tribes, as blood quantum gained ascendancy as a law to determine membership, gender, legitimacy, place of birth, and sometimes, when belonging is asserted, gave rise to what I call membership wars. Bitter civil strife internal to tribes regarding membership. These membership wars result in spirit-crushing collateral damage to those who find themselves outside the line. The terminology I use, ranging from Indigenous peoples, tribe, Indian, are terms used in the United States currently and historically. No term is universal. Some terms are used in statutes, some are used colloquially, and some terms are used officially. Indigenous tribes have names for themselves and for other tribes, and many tribal names are used and translated into English as the people. Sometimes these names are disclosed, often they are not. When distinguishing indigenous concepts of how indigenous peoples characterize themselves, I use the people in opposition to the idea of the tribe as a state, as that term is understood and used politically. In terms of human rights discourse, indigenous peoples is, of course, legally significant because self-determination is a human right that belongs specifically to those designated as peoples. And it is carefully and deliberately chosen and an appropriate descriptor. So that is the term that I prefer. In entering this discussion, it is necessary, as it is with most every subject related to indigenous peoples, to begin with the land. Not only because the land gives rise to our identity, but here the discussion of land is in terms of legal authority or jurisdiction over land. I begin with the legally significant term in the United States, Indian country. Indian country refers to a definition used in the United States federal statutory scheme to designate the specific Indian lands under federal criminal jurisdiction for prosecution of criminal activity. The statute simultaneously also describes historically recognized tribal territory over which tribes continue to possess full to limited concurrent jurisdiction, and in some instances exclusive jurisdiction. This term, Indian country, interestingly, was and is also used by U.S. soldiers, military strategists, reporters, and throughout the web to refer to hostile, unsecured, and dangerous military territory in Iraq and Afghanistan during the recent U.S. military interventions in both countries, and even earlier in Vietnam. Perhaps it's also being employed again with the latest operation against ISIS. Stephen Silliman, a historical anthropologist, refers to this as attesting to the term staying power in national narratives of colonialism at home and abroad. These narratives re-narrate uncritically the struggles and conflicts of Native Americans, past and present, through the lens of contemporary perspectives on terrorism. In contrast, Native peoples in the U.S. use the term to refer to their homelands, ancestral territories still remaining within their control and jurisdiction pursuant to domestic and international treaties with the U.S. and other nation states, which is Indian country today, which comprises only a fraction of the lands originally set aside as tribal lands. Perhaps this competing usage of the term Indian country today is illustrative of the complex inability of two worldviews on land to understand one another, even as they speak the same language and use the same terminology, because each embedded with deeply ingrained meanings that subjugate on the one hand and that seek to claim the promise of protected space and relationship to land, stretching back to time immemorial on the other. Section 18 U.S.C. 1151 describes the lands within Indian country as lands within any Indian reservation, including lands, patented lands and right-of-ways, dependent Indian communities, and Indian allotments, the title which is extinguished, including rights of way. This is Indian country for purposes of the exercise of federal jurisdiction by the United States over certain major crimes committed therein. There is an entire history bound up in this provision, with Supreme Court decisions to annotate each provision, and it represents a statutory codification of federal common law on criminal jurisdiction in Indian country. The term Indian country is also used when discussing civil jurisdiction, although this is a criminal, this definition comes from the criminal federal statutes. But civil jurisdiction, actually the jurisdiction of tribes generally, has been the latest object of contestation related to Indian lands in legal suits between tribes, the persons living within Indian country, states, and the federal government for the past 50 years. But that's a federal Indian law story. And the story that I seek to tell today is ultimately a tribal law story. Generally, in Indian country, with the exception of PL 280 states, tribes have criminal and civil jurisdiction in Indian country, and tribal courts exercise this jurisdiction. In this discussion of identity and mixture, the beginnings of tribal courts in Indian country is necessary context, because this is when the American common law tradition was introduced within what was previously exclusively a chthonic or indigenous legal tradition frame, with few exceptions. Those exceptions include the 5 civilized tribes who had adopted aspects of the American common law tradition, and the pueblos in New Mexico, where the Spanish civil legal tradition had intruded into the Pueblo civil governance as early as the late 1500s. After the devastation of the general allotment period, however, and the loss of millions of acres from Indian country, Indian agents appointed by the government held great sway over reservations. These Indian agents and later tribal police served as judges over courts, administrating judgments over their Indian charges on the reservation, with few exceptions where there were recognized tribal governments. John Clume, an Indian agent at the San Carlos Apache Reservation in New Mexico Territory, which is now Arizona, the state of Arizona, began to train Apache men to serve as police to assist him in his duties as agent. Courts and jails were introduced to educate Indians about the law. So successful was Clume's experiment that Indian police forces were introduced by other non-Indian agents throughout Indian country. So courts, police, and jails were brought to Indian country by reservation agents, all justified to teach and educate lawless Indians law. The law that was administered by these agents was known as the Code of Federal Regulations, and the courts that administrated this code were known as CFR courts. They were originally established in 1883. They were federal instrumentalities, administrative courts established by the Department of Interior, existing outside the federal constitutional court system. The law that they administered was truly draconian and repressive and intended to end the expression of tribal culture at that time, outlawing tribal dances, ceremonies, polygamy, in addition to other crimes, employing tribal police to assist in enforcement, and using jails to educate. This was the early history of tribal courts in Indian country. Tribal police were followed by CFR courts and jails in short order. In 1934, constitutions were introduced to assist tribes in organizing their government structures. The constitutions included provisions for determining membership status. Many tribal constitutions contained provisions with blood quantum requirements, setting a minimum amount of tribal blood necessary to be enrolled. This slide gives you an idea of the number of tribes that use blood quantum. Although it's dated, it's from 1996, it shows that of the tribes that are accounted for here, I think is approximately 316, that 21 of them required more than a quarter blood, 183 required 1/4 or less, and 98 had no minimum requirement. The reservation-based line shows that 85% of those that required more than 1/4 were reservation-based, as opposed to those with no minimum requirement, of which only about 64% were reservation-based. And then it also shows the median size of the tribes in each one of the categories. Currently, there are tribes that range their blood requirement from 5/8, which is a little over 1/2, to 1/64. And then, of course, those others who base their requirement on descent, where no minimum blood quanta is required. And this requirement can, of course, vary with members who are full blood to 100, 2,048 in the case of the Cherokee Nation. It was at this point in time when tribal constitutions with provisions for membership were adopted that tribal governmental structures or tribal courts began to replace CFR courts. The decision-making authority on membership issues has been recognized most famously in a 1978 case, Santa Clara versus Martinez, by the U.S. Supreme Court, that it is the tribe itself that possesses inherent authority to determine its own membership, and that it is for tribal courts to determine questions related to protections enumerated under the Federal Indian Civil Rights Act, which was passed in 1968, pertaining to tribal law on membership. No right of federal review existed under the Indian Civil Rights Act. So the question of who is a member of a tribe is ultimately a tribal one. The question of whether blood quantum is a sustainable one under the law of the tribe and the rights enumerated under the Indian Civil Rights Act is a question for the governing body, and in some cases the courts, where the courts have that review authority. Since Santa Clara versus Martinez, the federal courts continue to receive appeals on denials of membership, including cases of disenrollment of previously enrolled tribal members, or the denial of membership of individuals who were seeking enrollment in a tribe. The United States Court of Appeals in the Ninth Circuit recently commented, quote, cases about tribal membership often implicate issues deeply troubling on the level of fundamental substantive justice. The Ninth Circuit Appellate Court is perhaps suggesting that substantive due process claims to protect individuals against majoritan policy enactments that exceed the limits of governmental authority exist. That is, that courts might find that a majority's enactment is not law and cannot be enforced as such, regardless of how fair the processes of enactment and enforcement actually are. The Supreme Court in Rochin versus California and 1952 case had ruled along these lines that laws that shocked the conscience of the court were generally deemed unconstitutional. So, the question that I move to is, does blood quantum law shock the indigenous conscience? Indigenous law has always existed to govern who we are, to govern and guide our behavior, and to use the live-in law that continues within our communities as the guiding principle for our societies. In this diagram, this shows an illustration of the chthonic legal tradition in Pueblo communities, with the dark line illustrating law that has evolved under the chthonic legal tradition from time immemorial, and the different parts of the design to show where law fell into disuse, and then the progression of time, but also how the law has been reincorporated and come into use to illustrate not only the beauty of the chthonic legal tradition, but also how it is able to continue and to create new frames and new structures. Thus, it is the living law. Because law and culture are inextricably intertwined, as cultures and legal traditions meet, they began their struggle with one another, with the dominant insisting on asserting its superiority, and with the chthonic legal tradition looking to continue to convince, in the words of international comparative law scholar H. Patrick Glenn. I use tribal law to refer to tribal enacted law or constitutional law that is written in English and adopted by tribes, as opposed to the chthonic legal tradition. Tribal law that is enacted law is created by tribal legislative bodies, much like law is created in the common law tradition by legislators. Chthonic law, or the indigenous legal tradition, is existing law in operation that these legislative councils did not and do not enact. It is the law that existed before the civil and common law traditions were brought by the Spanish and the Americans, and that continued and continues moving of its own accord among the peoples. It is unwritten oral law. It is law that does not sit well with the law that arises from the civil and common law legal tradition. It is law that sits outside of these legal traditions, literally and figuratively, because it is law that arises from the indigenous knowledge frame embedded in the land, in the native tongue, in the processing of thought, and according to its own process that is not easily adapted to or ordered in the same manner as the Anglo-American common law or the common law or civil law. As a veteran of the tribal judiciary, having served at the trial and the appellate court level for various Pueblo communities since I graduated from law school, I have experience with what I call the dissonance between the Chthonic legal tradition and the common law and civil legal traditions. And it is this dissonance that drives my work, seeking balance. Apart from my experience as a member of the judiciary, generally I feel the absence of the core values of the community in the approach and process of tribal courts, modeled after Anglo-American common law systems, both in the foundational thought and philosophy, but also in the response of the parties that have appeared before me and other tribal judges to adjudication, which concerns itself less with bringing parties together over dispute or transgression and more with declaring a party right. It works to end dispute, but it does nothing to right relationships, to acknowledge the fluidity in truth, that even when you are wrong, you can be right. And worse, even when you are right, you can be wrong. Tribal communities are entirely relationship-based. The peoples are related to one another by blood, marriage, and through societal relationships. The majority are small in respect to population, ranging, for example, for Pueblo communities in size from a few thousand to a few hundred. Zuni Pueblo, which is the largest Pueblo in New Mexico, has a population of 7,627 at the last census. Sandia Pueblo, which is one of the smaller Pueblos, has a population of 430. They are small, close-knit, and closed communities. The majority of tribes in the U.S. fit this demographic in terms of size. Many of the 566 tribes in the U.S. determine membership based on blood quantum, as we saw from the previous slide. The issue of membership criteria for tribal enrollment has become one of the most hotly contested issues for tribal peoples within the internal tribal political frame. It is an issue fraught with the politically and emotionally charged intersections of law and gender, identity, interracial and intertribal mixture, and paternity or legitimacy. The intertribal disputes generate extremely high-stakes legal challenges in tribal and federal courts. My focus here is on tribal law and tribal legal approaches to resolving these disputes. The use of blood quantum in respect to indigenous peoples in the United States dates back to British colonial rule, but blood quantum, or mixture of blood, has nefarious roots for determining African American ancestry and discrimination in the pre-civil rights era, the Casta system in New Spain, which created 16 categories of mixture and rankings based on that mixture with largely derogatory names. Mixture with African slaves and indigenous peoples occupying the bottom, for example. This shows the Casta paintings, which were really a grouping of paintings to show the mixture and the status resulting in that mixture. This is an excerpt from the larger frame showing numbers 6, 7, and 8. And you can see that each of the frames, which show a couple and a child with names resulting from the mixture. So that number 6 shows the chino, which in Spanish is short for cochino. As if you know Spanish, that is pig. Number 7, showing the mixture between chino with Indian as bounces back. And number 8, showing the mixture of bouncing back with mulata as lobo, which in Spanish is wolf. The adoption of blood quantum during the Indian Reorganization Act period, when tribes were adopting constitutions, and its continued and prevalent use by tribes right up to the present, represent one of the clearest examples of how no peer chthonic legal tradition exists today. All have been impacted by the dominant legal traditions of the states in which they exist. The template for tribal governance laid in 1934, which was a constitutional frame of democracy, really for municipalities, and the template of law provided by the early Code of Federal Regulation gives rise to the dissonance of the common legal tradition and the chthonic legal tradition, out of harmony with one another and operating in constant ignorance of one another, it feels. The study of the diversity of legal traditions is what led me to the understanding of the source of the dissonance that I feel. We have a system of law and a structure. We have the recognized authority and jurisdiction, but the template upon which our system seeks to operate is not our own. There are complexities in this common law chthonic legal tradition. The people in the community are socialized to an unwritten chthonic law. It is encoded in the mother tongue. It is there in the proper relationships that we know we are to have with one another, even when they escape us. The way we are to treat one another and behave towards one another, they are there in the texts. Uncommon to our brothers who follow the common law legal tradition, the text in the land, in ancient symbols, in the core values we are socialized in the beliefs, in the stories, in our journey narratives that brought us to the places we call by our own name, in our songs, in our ceremonies, in the patterns of the seasons. Yet this does escape the tribal common law court, the written law of tribes, the process of the courts. So it is with the law of blood quantum. Considering the law from a chthonic legal tradition, what do we see? Tribal communities are based on kinship relationships. We are connected to one another through blood, marriage, and societal structures, including clans, societies, acequias, irrigation ditches, and other ancient and emerging subgroups. Relationships are sorted out in terms of a known relative. We are identified as daughter of, sister of, grandson to, mother of, going back as far as or until a familiar person is recognized as is necessary. A known relationship establishes belonging. The caring for and strengthening of these relationships through succeeding generations is continuance. Setting a percentage of blood quanta establishes a limit on belonging and continuance. In fact, it draws an actual line that sets the limits of legal enrollment in a federally recognized tribe in federal Indian law, or American common law legal tradition parlance. It is a line for the tribe as domestic dependent nation or quasi-political state, and for the federal government's responsibility to a tribe's members as set by each tribe. Ironically, and in some cases, that line for federal responsibility and federal criminal jurisdiction extends further beyond the tribal line. This is the consequence of the introduction and continual incorporation, or perhaps it is the acquiescence leading to acceptance of common law and civil legal tradition into the space of peoples still adhering to chthonic legal tradition at a social and a cultural level. Blood quanta lines provide certainty. They imply more or less equal treatment of all those meeting or not meeting clear criteria, but blood quanta requirements represent introduced law, not emanating from within or based on a view of continuing relationship. In actuality and on the ground, relationship to those outside the blood quantum line is not severed. The relationship and responsibility to one another continues to relatives beyond the line. Chthonic peoples governed by the chthonic legal tradition would not draw a line severing relationship. That would be anti-chthonic. The introduced written law clashes with the fundamentally fluid chthonic. I state the obvious. Two legal traditions are in play in modern tribal communities. One is clearly seen. It is seen in the tribal court, modeled after the American legal tradition and the written law. The other is not clearly evident without close examination. It requires a deeper look. It is similar to that experience of viewing metamorphic art, like that of Mexican artist Octavio Ocampo. However, in the case of the imported common law tradition and the indigenous legal tradition, what is embedded is not necessarily in tandem or related to what is clearly seen. In this, if you look closely, maybe you've already seen it, you can see this is the Virgin of Guadalupe Hidalgo, but her face contains the story of the Virgin and its viewing by an indigenous man. In her eyes, you can see two men. Here are the angels looking over, and here, which is much harder to see, but you can see the Virgin appearing there. And so that is the type of art that I compare to law that is there, but that takes an eye to see. This is another one of his paintings in which you see what you see. But it's this juxtaposition of legal traditions when they do not relate to one another that is the source of the dissonance that I feel between the so-called written tribal law and the chthonic law that continues in operation but not in writing, and which affects the feeling of the law as well as the process of the application of the law in tribal courts. So the system that we have, which is the tribal court system modeled on the American legal system, is a system that we have. There are at least 4 obvious points of intervention for most tribes: where law is made, where law is applied, the tribal bar, and the parties before the court. I began with the premise that the indigenous legal tradition is living and in operation in tribal communities. It is patterned into what we know of the land, the language, and in the protocols. It is in the everyday, and it is in the ceremonial. It is simple, and it is complex, and it requires a patient jurisdictional reader and reading. So, what to do? What is required is a recognition that the introduction of a common law legal approach into a space already filled with the chthonic legal tradition gives rise to an entirely new set of jurisprudential questions for indigenous peoples engaged in the building of a legal system of their own, with borrowed common law trappings, for a peoples and in a space adhering in various degrees to a chthonic legal tradition. The principle that it brings to my mind is that of water bending light. The chthonic legal tradition, the living law in the people, which is still in operation, bends the common law and the common law legal approach. And it's not just a matter of perception, it's a matter of reality. And until we understand what this means for our jurisprudence, we will have laws and courts that cannot quite capture how the people feel, even as the introduced common law system operates or tries to, as it does outside. So I leave you with more questions than answers. What is the relationship of the chthonic law to the introduced common law, traditions, and legal approach? Is a chthonic reading or interpretation of the law necessary? Is it legal under the chthonic legal tradition to cut off relationship? When is it legal? What are we to do when there is a clash or irreconcilable difference between chthonic and common law? I speak from all three of my roles, as justice, as law professor, and as a lawyer, when I consider these questions. We must train ourselves beyond the common law legal tradition. We must understand and theorize our own jurisprudence. To do so, we must understand the historical and present condition of the chthonic legal tradition in our own communities. We must understand our legal history for our specific tribal communities. As lawyers, we must understand our dual roles as lawyers. We may be legal warriors externally fighting for our rights, but internally within our communities, we are not so much fighting as seeking to help our people heal. We are engaging with law for a different purpose. Saskatchewan Henderson spoke of Indigenous law as love at the annual Indigenous Bar Association conference at Calgary. He said we don't understand law with our minds. We understand it and engage it with our hearts. Inside, our roles shift. Inside our own communities, they shift. We are not at war for our rights because we are engaging with our own people, struggling to bring back law back into relationship with who we are. And then I just end with the Article 9 and Article 33 of the UN Declaration on the Rights of Indigenous People, which set out rights pertaining to identity and belonging in indigenous communities. And Article 33, the right to determine, indigenous people having the right to determine their own identity and membership in accordance with their own customs and traditions. Thank you.